I'm here today with Chris Brennan, the head of our procurement practice, and we're going to talk about the ways in which we are seeing people attack public procurement decisions. So Chris, what are you seeing about the approaches people are using to attack public procurement decisions?
Well, what we're seeing is that they are looking to a broader range of grounds on which to actually base an attack. I think we're seeing attacks get more aggressive. Maybe that's due to the economic climate, but we are tending to see departures from simply basing an attack on breach of the public contracts regulations, our domestic procurement rules. And we're starting to see broader grounds used for these challenges.
Why do you think that is?
Well, I think that there is an increasing tendency, perhaps again in these economic times, for suppliers to think that they have less to lose by attacking a decision, or perhaps they have more to lose if they just sit by and accept the fact that they've lost a contract, which could be a very important contract for them. And so I think this is probably the new normal, actually. I find it difficult to see any kind of backtracking now from where these things seem to be going.
So if you are an aggrieved supplier, what legal grounds might you consider using to attack a public procurement decision?
Well, perhaps at the top of the list is looking to the public contracts regulations, assuming of course this is a public procurement, for the basis for your attack. So most commonly we see aggrieved suppliers saying that the contracting authority has breached the principles of equal treatment, transparency, non-discrimination, etc., and basing that on the relevant parts of the public contracts regulations. But that's not just it. We're also seeing increasing use, if you call it that, of the state aid rules as perhaps the basis for a particular ground, a particular peg on which to hang a challenge. Competition law, increasingly and perhaps intrepidly. General public law duties, which all tend to go hand in hand, I think, with good public procurement. We're seeing people say that they think those have been breached as well. So things like the social value duty, the public sector equality duty, and broader public law principles. So they're tending to throw in the kitchen sink more than perhaps they used to.
And what routes are available if a supplier wants to launch a challenge?
So in terms of the legal basis, or I suppose the legal route to mounting a challenge, generally speaking, challenges in England to decisions made under the public procurement rules are brought in the High Court under the specific statutory regime set out in the public contracts regulations. And that is the case for economic operators, so suppliers or would-be suppliers who would have wanted the chance to bid for a particular contract. However, we're also seeing and actually perhaps have been seeing over the course of the last 3 or 4 years, maybe now, increasing use made of the judicial review route. Now, there are questions as to which routes are actually available for which types of challenges. It's, I think, fairly clear now that any old Tom, Dick or Harry can't use the public contracts regulations route. That is specifically a route for bidders, aggrieved suppliers, would-be bidders, that sort of people. But what about someone who maybe is a non-bidder, or someone who perhaps isn't in competition with a bidder? Would they still have a route to challenge? Well, actually, in the right circumstances, and specifically if they can demonstrate a sufficient interest in the proper running of a procurement procedure, then they might actually have standing to use the judicial review route to mount an attack on the particular procurement. But that won't be the case under any circumstances. They would have to show not simply, for example, that they were opposed to the whole point of the procurement or opposed to the end result, whether it be let's say an academy or something like that. They'd have to show that they had a sufficient interest in the proper running of the procurement process itself in order to have that standing.
So have there been any recent cases where judicial review has been used to challenge a decision?
As a matter of fact, there have. We can all think back, I think, to the Virgin West Coast franchise fiasco. And in that situation, Virgin actually considered judicial review as a means to challenge rather than proceeding under the public contracts regulations. And there was actually a specific reason for that. It was basically to do with the fact that the type of service, the rail franchise, isn't a fully regulated contract, so the procurement rules didn't apply to that particular process in full. In that situation, there is a question mark over the extent to which a remedy is actually available to an aggrieved supplier under the traditional public contracts regulations route. And so in that situation, you're looking to alternative means of challenge or attack that might actually stand you in with a better chance of an actual remedy. Another example in which one might seek to use judicial review is where one is not actually a supplier or an aggrieved bidder, so in other words hasn't participated in a particular procurement at all, but seeks to challenge public procurement on some other basis or in some other capacity. So for example, if one is politically opposed to, let's say, academies, and one looks to JR to challenge the procurement of an academy simply because of an opposition to the whole idea of academies, let's say, well, that won't give the attacker the standing that is necessary in order to mount a successful judicial review challenge on that procurement. What the person would need to show is that he or she had a sufficient interest in the proper running, the proper conduct of a good public procurement to mean that actually there was a sufficient interest there.
And are there any set timescales for challenges? And are there any exceptions to those timescales?
There are. Under the public contracts regulations, which, as we've said, is the traditional route to procurement challenge or to attack a bad procurement decision, the timescale now is actually very short. It's 30 days from the date that one knew or should have known of the existence of grounds on which to mount that attack. In standstill period situations, of course, it's still 30 days, but if one wants to be guaranteed with a chance of actually halting the award, then of course the 10-day standstill window provides that visibility that actually during that standstill period no contract will be entered into. And therefore, someone might have to move very, very quickly indeed in that situation. For claims for ineffectiveness, which is a completely different territory, it's where there's been an award without competition at all, let's say, so an illegal direct award in circumstances where there should have been a procurement, well then the challenge period can be anything up to 6 months from the date that the offending contract is entered into, unless that period is actually shortened, which it can be in certain situations.
Given that the 2006 public contracts regulations already provide some useful grounds for bringing a challenge, why would suppliers look to use other remedies?
Well, there could be a number of reasons. First of all, if we take perhaps an obvious one, state aid is a ground that we're often starting to see now sort of bolted on or almost used as a line in a procurement challenge situation, where the challenger is saying that because the procurement has been flawed, then that means that either state aid has been conferred on the successful bidder or the contracting authority hasn't been able to make sure it hasn't been conferred. And that actually is quite handy because, for a start, state aid challenges, let's say the attacker wants to reserve the right to complain about illegal state aid, which happens to have arisen out of public procurement. The timescale for doing that is much, much longer. It's 10 years. It's up to 10 years from the date that aid was conferred. Now, the route that it would actually use to do that is completely different, so it's not the traditional High Court route that you have under the procurement rules. However, it is used as almost a strapline increasingly in a procurement situation. And actually, it's perfectly logical, I suppose, that perhaps that should be seen, because if a procurement has been faulty, or there's perhaps been post-tender negotiation, let's say, with a successful provider, which has meant that its price has been increased, then really it's difficult to see in that situation just how any risk of state aid could have been avoided. How will the contracting authority know that the ultimate contract that it ends up with is market, when actually there's been post-tender negotiation without any kind of competition or competitive tension around it?
And can you just talk me through some of the other grounds that you've seen used?
Okay, well, to name but a few, competition law is sometimes used. Now, I say sometimes used, we have occasionally seen the competition law line used in, let's say, a letter before claim or a grumbling letter as a precursor to a formal challenge. Whether or not that ground actually goes any further might be a bone of contention, because competition law is a particular animal and it involves a particular set of rules, and it might be difficult to actually, for an aggrieved supplier to substantiate that and say, you have breached competition law for the following reasons. So it sort of looks good in an initial letter. Whether it ultimately develops into anything, it's difficult to see sometimes. But what we can say is that there has been recent case law where a competition law was used as the basis for a challenge, where the circumstances of the challenge happen to have been a procurement. So there, it's actually a case involving Luton Airport and a bus service between there and London Victoria. An incumbent bus operator who had lost the ability to continue to provide the service mounted a competition law challenge on the back of losing the public procurement, on the basis that the airport operator, i.e. the authority running the procurement, was an undertaking for competition law purposes, so it was an entity capable of breaching competition law, and that it had breached competition law by awarding an overly long period of exclusivity under the contract that it had just awarded. So that was a situation, perhaps a rather special situation, in which the circumstances were right for a procurement challenge actually to be run as a full-blown competition case. That clearly won't always be the case, but in the right situation, it could be. Now, we're also then starting to see other public law grounds used as the basis for attacks, and notably the public sector duties that arise in the context of public procurement. So the public sector equality duty is one. That's a general duty which applies to the public sector really in whatever it does. Then we have also the Public Services Social Value Act 2012, and the specific procurement-related duty that act imposes on an authority to consider the social, environmental and economic well-being of the authority's area at the pre-procurement stage when it's procuring services. The public sector equality duty is one of more general application, and again, in the right situations, one can perhaps make out grounds to challenge public procurements on either or both of those bases ultimately. So it'll all come down to the particular circumstances and whether or not they lend themselves to a challenge on these wider grounds. But again, they might and they sometimes will. What is always also available is perhaps an opportunity to challenge, by way of judicial review, the broader public sector decision-making remit of a contracting authority, which might happen to be in the context of a public procurement. So one can perhaps sometimes find the basis for saying that a decision to award a particular contract to supplier X is unreasonable under the so-called Wednesbury principles, in other words, so manifestly, outrageously unreasonable that no reasonable authority could ever have made it, in effect. You might also have the ability to base a challenge on broader public sector principles of public law principles of good decision-making, good administration, legitimate expectation, and sometimes also perhaps the failure in the duty to consult, which increasingly might now arise in certain types of procurement, involving perhaps, let's say, to take an example, social care procurements, health services procurements involving groups of service users, that sort of thing. So we can see from all of this, I think, that there are broader grounds, there can quite often be broader grounds found than simply looking to the public contract regulations in relation to procurement challenges, and we're starting to see it happen.
And so finally, Chris, what do you think are the key issues for in-house counsel to take away from today? What are the things they should be taking back to the office and actually actioning?
I suppose that from the contracting authority side, so in-house counsel acting for their public authority clients, should probably be maintaining a wider field of peripheral vision than perhaps might have been the case previously, a few years ago or whatever, in that one should be looking to really start to future-proof procurements and try to tick as many boxes as possible in terms of fielding off any possibility for potential challenge on whatever basis. Now, that may well not be easy, and perhaps it's virtually impossible. But I think we would be saying to them that actually they need to be thinking about that. In-house counsel on the supplier side might perhaps take some comfort from maybe the truism that there's really no such thing as a perfect procurement. And that more often than not, a chink in the armour might well be found somewhere. That, of course, will be one's appetite for actually challenging, actually going into that attack mode will depend on the risk, the appetite for it generally. So how much, what extent does the supplier think that it has anything to lose by doing so? And of course, in any situation, a supplier will need to be fully advised and appraised of the merits of the claim on whatever basis, the costs, the risks. And in public procurement, this sort of situation is fraught with all of those.
Thank you, Chris. That was really interesting, and I think we've all got a much better understanding of the way this area of law is developing. Thank you.
Thank you.